Dear students, after studying this module, you shall be able to know what are the police roles in dealing criminal, what are police strengths and organization in India, how to do complaints of crime and criminal, what are the police accountability and commitments, what are the roles of police in court and defense. First, the introduction. Police role in dealing criminals. The police press charge against the person you believe committed the criminal act should be based on a determination by the police whether a crime took place or there is enough evidence to charge the person with the crime. Criminal cases are speedily processed. Step 1. Recording of the first information report, that is FIR. Criminal justice process is firstly written with the recording of the first information report. Step 2. The law enforcement agency officer directs to the crime scene and examines the evidences of the case. Police investigations are crime scene investigation, examination of suspects and witnesses, statements, conducting searches, property seizing, collecting footprints, fingerprints and other methodical evidences, making records and archives in the approved records such as case daily diary, etc., making detentions and arrests, and accused interrogation. Now we will study about police strength and organization in India. Police strength. On January 1, 2001, the state police forces total strength was 14,49,761, out of which civil police constituted 10,77,415 and the armed police 3,72,346. Maharashtra has the major police force, that is 1,59,888, while Dadar and Nagar Haveli has the minimum contingent, merely 213 persons. Now, police forces that are sanctioned in states and union territories. As on 1/1/2001, the given table shows the number of sanctioned strength for states and union territories in case of civil police, armed police and the total strength, police per 10,000 population and police per 100 square kilometers. Now, growth of police strength. The growth of police strength has been significant and growth in police manpower since independence. In 1947, the police total strength in different states and union territories was about 3.81 lakhs. By 2001, the strength has increased to 14.49 lakhs. Police has a hierarchical structure with the Director General and the Police Constable of Police at the two extremes of the organization. The police organization base is very heavy, with constabulary accounting for about 87.61% of the total strength. The upper subordinates, that is inspectors, assistant sub-inspectors and sub-inspectors constitute about 11.51% of the total strength. Now, the organizational structure. State government exercise superintendence of the police force in the state. Director General of Police, DGP, is the head of the police force in the state, which is responsible for advising the government on police matters and for the police force administration in the state. Now we'll see the police force field establishment. At the top is the DGP, that is Director General of Police. Beneath him is Additional Director General of Police, then Inspector General of Police, that is the IGP, then Deputy Inspector General of Police, DYIGP, Senior Superintendent of Police, that is SSP, Superintendent of Police, SP, Additional Superintendent of Police, Additional SP, Assistant or Deputy Superintendent of Police, that is ASP or Deputy SP, then Inspector of Police, that is the in charge of a police station. Underneath him is Sub-Inspector of Police, which is SI. Then is Assistant Sub-Inspector of Police, ASI. Then is police head constable HC, and finally the police constable at the junior most level. Now, complaints of crime and criminal. You can report any crime to the police as soon as possible. You are under no obligation to do so. At any police station, you can report a crime either in writing or verbally. Now, criminal complaints. You can file a criminal complaint if you are a victim of a crime. You must file a complaint within 3 months of the incidents. You can make the complaint against a person or against persons unknown. You can withdraw the complaint, but if you are injured or at loss or damage due to the crime and you want to report, for example, you are not covered by insurance, you have to file a criminal complaint. You don't have to contact a lawyer, but in complicated cases, it is advisable to consult one. Then is reporting a crime. Anyone who is aware that a crime has been committed, that can be reported. Even if you do not know who committed crime, you can report it. You can make a written report to the public prosecutor. Now we'll study about the procedure for a criminal case. The same procedure has been followed since 2011. The police investigates the incident that has taken place. The public prosecutor's office that has jurisdiction over the case decides whether there are enough evidences to bring charges at the end of the investigation. The public prosecutor responsible to bring up the case to the court and conducting the trial, the accused can provide evidence that she or he is not guilty at any time. The judge listens to the evidences and arranges for any other evidences to be taken and issues a verdict at the end of the trial. If you are convicted of a crime, you can challenge the decision by filing an appeal. It is very meaningful to consult a lawyer before doing this. The person who has reported a crime can ask the authorities whether criminal proceedings have been brought up or not. Complaints procedure. Interpol provides a mechanism for complaints about the blocking of a domain, and links to this will be available on the generic stop page. If your ASP does not use a stop page but you think that you may have been blocked, you can refer to the Interpol complaints page. Complaints from owners of domains that are affected that will be handled by Europol's funnel web solution. Links to this will also be provided on the stop page. Next is evaluation of complaints. The Interpol General Secretariat, that is IPSG, will handle internet users' complaint and will re-evaluate reported domains. The domain will be removed from the list and will be available to assess. If found not to contain child sexual abuse material according to the defined criteria, the illegal material may present at another address on the affected domain than the one you are trying to assess. Next is treatment of complaints. Valid complaints from domain owners will be distributed to the Interpol General Secretariat and all other countries operating national blocking systems for re-evaluation. If found not to contain child sexual abuse material according to the worst of list criteria, but still the illegal material according to national legislation in many countries, the material will remain inaccessible in those countries. The countries themselves will handle feedback to the domain owner complaints within the CIR CAMP system. Next is police accountability and commitment. Need for accountability. Since it is the safeguarding of democratic processes by a principal function of police, high priority must be given to ensure that the police are made fully accountable to the public for their actions and to their police administrator. The police should remain committed to none of these but only the role it is expected to perform. What is the difference in the four priorities and why is commitment to role given top priority? The police to remain committed to the political executive are required by the Police Act of 1861. Learned police officers like N.S. Saxena, former Director General of CRPF, Delhi, and senior expect police to remain committed to law. The National Police Commission suggested that the police must be more concerned with protecting the interests of the people. That is, it must remain committed to society. It holds the role commitment on one of the police part is more important. Everyone knows that our political rulers use and misuse the police for their interests. The unsurplus, self-seeking politicians abuse the strong arm of the police for their partisan ends. Police commitment. Police commitment to law should thus mean that the police have the order to flout the orders for their political houses if they considered the orders for maintaining law and order in society. In this situation, if a police superintendent wants to arrest a highly placed bureaucrat in violating the law, and if he is asked by the minister concerned not to do so, the superintendent of police must not bother to carry out the minister's orders but arrest the officer concerned. Now lays the commitment of the police to people or to the society. In this case, even if the policemen have to deviate from the existing laws, they would do it not only for protecting the life and property of the people, but also for bringing the most corrupt politicians and bureaucrats to the notice of the people and for arresting and prosecuting them in the courts. The concept of police accountability has to change, keeping in view the new goals to be achieved. Let us hope that soon the police role will be redefined and there would be effort to make it an instrument of service to the people. Now, what are the limitations of powers of a police? Due to the critical nature of the police function within government, legislation must provide that there is no right to strike. Effective to the right to strike must be made available as methods by which police officers may pursue their collective interest, and model procedures governing this important matter should be developed. The right of police to engage in collective action should be subjected to the following limitations. First, the governmental control, preservation over law enforcement policy making requires that law enforcement policy not be the subject of collective bargaining. Second, the need to maintain local control on law enforcement and on law enforcement resolution policy issues requires that law enforcement policy is not determined by the other police employee organization or a police union. Third, the maintenance of police is objectivity position in engaging in conflict resolution requires that police not belong to a union which also has non-police members who may become party to a labor dispute. Fourth, the proper maintenance control by the police administrator over the department requires that collective action not interfere with the administrator's ability effectively to implement the policies and objectives of the agency. Fifth, the potential for conflicts between the collective interests of line employees and management personnel requires and supervisory that were feasible separate bargaining units be required for these classes of employees. Now, the role of police in court and defense. Current responsibilities of police. In assessing appropriate objectives and priorities for police service, local communities should initially recognize that most police agencies are currently given responsibility by design or default to identify criminal offenders and criminal activity and where appropriate to apprehend offenders and participate in subsequent court proceedings. Next is to reduce the opportunities for the commission of some crimes through preventive, patrol and other measures. Next, to aid individuals who are in danger of physical harm. Next is to protect constitutional guarantees. Next is to facilitate the movement of people and vehicles, to assist those who cannot care for themselves, to resolve conflict, to identify problems which are potentially serious law enforcement or governmental problems, to create and maintain a feeling of security in the community, to promote and preserve civil order, and to provide other services on an emergency basis. Now we shall see what are the duties of the police. The Police Act of 1861 laid down the following duties for the police officers: execute and obey all orders and warrants lawfully issued by any competent authority, communicate intelligence and collect affecting the public peace, protect commission of offences and public nuisances, bring offenders and detect to justice, apprehend all persons whom he is legally authorized to apprehend and for whose apprehension sufficient ground exists, preserve and promote public order, investigate crimes, apprehend the offenders where participate and appropriate in subsequent legal proceedings connected therewith, identify problems and situations which are likely to result in commission of crimes, reduce the opportunities for the commission of crimes by preventive patrol and other prescribed police measures, cooperate and aid with other relevant agencies in implementing the prescribed measures for prevention of crimes, aid individuals who are in danger of physical harm, maintain and create a feeling of security in the community, facilitate orderly movement of people and vehicles, resolve conflicts and counsel and promote amity, provide necessary affordable relief and services to people in distress situations, collect intelligence relating to matters that affecting the public peace and crimes in general, including social and economic offences, national integrity and security, perform such other duties as may be enjoined on them through law for the time being in force. How do police officers work with the court system? Police officers are not part of the judiciary. They are an element of the executive because of enforcement of the laws made by Parliament. Because police officers act as separate to their actions and are highly scrutinized by the courts and the judiciary. If police officer instigate action to bring an offender before the court, an officer needs to consider the evidence for obtaining that evidence and whether or not their actions and decisions will stand up to judicial scrutiny and prosecution. It's finally the court and not police officers that determine the guilt or otherwise of the offender. Before an officer arrests a suspect for an issue or offense, a notice to appear the officer needs to ask themselves, is there sufficient evidence? And public interest implies that on determination of all the facts and circumstances of a case, the public interest is served in pursuing a prosecution. Example, it is more likely not in the public interest to prosecute an 80-year-old intellectually impaired person for stealing a drink which is just worth $4. It is also the policy of police written in section 3.4.3 of the Operational Procedures Manual that an officer's decision to prosecute or not to prosecute must be based upon the evidence and the law and never be influenced by, first, race, sex, religion, political views, national origin. Second, personal feelings concerning the victim or the offender. possible political advantage or disadvantage to any political group or the government or the party, or the consensus of a decision by those responsible for the prosecution. The evidence a court will allow a police officer to place before it is subject to rules. In a court trial, evidence will evolve around witnesses' oral testimony, documents such as certificates and other written evidence, and objects. Example, on a thieving complaint, it might be the stolen property. It is more important that police officers conduct their investigations in compliance with the law. For example, police officers may be capable to stop a vehicle and search for evidence of an offence. This influence present under the Police Powers and Responsibility Act of 2000 is legislation that informs police members that they can lawfully do. If an officer fails to comply with the legislation, the evidence they obtain can be held by the court to be unlawfully obtained, and hence an offender may have the charges beside them terminated. The Police Powers and Responsibility Act of 2000 is a vital legislation that can persistently be mentioned during their training and during their policing career. When do police officers go to court? Additionally, a police officer goes to court for applying to the court for directions on behalf of sufferers of domestic violence, for attending court as a witness, to be the court systematic, for attending court to file leaflets related with court issues, and for obtaining sanction from a magistrate for examination of locations, and for attending court to have a court worker issue a search warrant. How do police officers defend in situations where defendants face court? The offender has to be dealt with by a court. If an individual is charged with some offence, the first attendance of any legal offender is in a magistrate court. To assist the court with pleas of guilty, police department officers can describe the important facts of the offence, providing all supporting documentation such as traffic histories and criminal witnesses available, dates and affidavits for opposition to bail. In planning for the lawbreaker's appearance, the police officer prepares papers in order that a prosecutor will notify the court of matters relating to the offence and details about the offender's antecedents. The police officer will make the document for this purpose is known as a court brief. The document contains a summary of the facts which the police officer alleged will prove the offence. There will be no need for the officer to present court, as the prosecutor can inform the court about the matter. If the papers are forwarded in the court brief, absences certain important information, justice may not be done. If a police officer presents evidence before a court, it needs to be a fact. Therefore, attention to detail and accuracy are critical matter of police work. When an alleged offender pleads not guilty, the matter will be in trial. The IO, that is the investigation officer, is then accountable for making a brief of evidence and organizing for witnesses to attend a hearing date for giving evidence. A brief of evidence is collection of all written statements of witnesses and documents related with the charge or charges being contested. The police officer then attends the trial with the witnesses and the exhibits. Now we will conclude this module with the summary. FIR is the document that is made by the police when they get information about the cognizable offence which has taken place. State police officers or forces overall team was around 14,49,761 on January 1, 2001, out of which civil police comprised of 10,77,415 and the armed police was 3,72,346. Superintendent of the police force of state is implemented through the state government. Police force head in the state is the Director General of Police, DGP, who is responsible on state government for administrating the law enforcement agency of the state and for governing on police matters. You should report any crime to the police as soon as you can. You are not under any compulsion to do so. In any police location, you can report a crime, either verbally or in writing. Assurance of police force to rule will thus means that the police have the inherent authority to flout the orders of the political houses if they considered in maintaining law and order in society. Police accountability has thus to change in reference with the new goals to be achieved. The right of police is to engage in collective action, in using ideas and maintain concern for local communities. Police service should recognize that current given responsibility of most police agencies are by design or by default. The offence will be approved by the police officer alleging. Thank you.